Hi, so you've been appointed a power of attorney. What does this mean? In New South Wales, a power of attorney is limited to finance and property decisions. So when you are appointed an attorney for someone, it means you can make property and finance decisions like you can for yourself. You can deal with the money and property just like you can for your own property and money. Obviously, when you are appointed an attorney under a power of attorney, you are placed in a very high trust position. In fact, at law, this is called a fiduciary relationship. A fiduciary relationship brings with it certain obligations, including, most importantly, the obligation not to benefit in any way from a decision made under the power, and secondly, to always act in the principal's interests. Under the powers of attorney, you are also required to keep good records, and you're required to keep your money and property separate from the principal's. So this means that if you are appointed an attorney, unless specific powers have been granted, you cannot use the money or property in a way to benefit yourself. This includes contributing towards household and normal expenses if the person is actually living with you. Unless they've given you a clear direction to that effect, you can't just simply set up direct debits, for example, contributing to household bills. You can't use their money to go on a holiday or to transfer their property to yourself. Unfortunately, these might seem obvious, but we have seen many cases where attorneys have simply done these things to benefit themselves. If you are in a situation where there is a decision that you have to make that is, you think, in the best interest of the principal, but you actually may also benefit from the decision as well, then you actually have an obligation to go to the court and seek guidance. The court is there to assist fiduciaries and trustees to make decisions like this and give authorisation to them. So down the track, the trustee or fiduciary, or the attorney in this case, is not subject to litigation that arises from such a decision being made. It's also important that you be transparent, particularly if you are an adult child and there are siblings involved. It's far better to be transparent about the decisions being made and how the money is being spent to avoid potential conflict. We also recommend that you liaise with the principal's bank. It's best not to simply take over their debit cards and their internet banking, but to actually go to the bank and get your own access. This will assist in keeping records separate so that it's quite clear whether it's been you undertaking the transaction or whether it's been someone using the principal's identification. If you are concerned in any way, we are here to help. We are specialists in the area of elder law, powers of attorney, enduring guardianships, wills and estates. Don't just go to anyone. There's a lot out there that don't seem to know the law as well as they should. Come and see us, LS Legal, 1300 883 942 in Beecroft, Northern Beaches and the CBD.